the national lawmaking process. There's a specific question raised in the material. There are arguments that bills of national importance should be placed before the Interstate Council prior to their introduction in the Parliament. Discuss in light of the issues that have been observed in the passage of bills in the Parliament in recent times. So the Interstate Council, the ISC, suggesting it should review major bills before they even hit Parliament. I mean, that sounds like a pretty big change. Why? What's going wrong with the current process?
Well, the sources point to a few key problems, and they seem to add up to what some are calling a trust deficit.
A trust deficit. How so?
It seems to stem from a perceived decline in the quality of scrutiny that bills receive. There's this phrase used, the decline of Parliament.
Right, I saw that. And it's linked to fewer bills going to parliamentary committees.
Exactly. These committees are crucial, They're where detailed, often nonpartisan examination happens. If bills bypass that stage, or if the committees don't have enough time, well, potential flaws might not get caught.
And it's not just about the quality of review, is it? It's also about the time Parliament actually spends working productively.
That's another big point raised. The sources mentioned data, I think, from PRS legislative research.
Yes.
Showing that a surprisingly small percentage of questions posed by MPs actually get answered orally in the House. Less than 10%, apparently.
Wow, less than 10% because of disruptions and lost time.
That seems to be the main reason cited. Frequent disruptions eat into productive hours. So if you have less time for debate, less time for questions, the accountability mechanism weakens, doesn't it?
It absolutely does. But the sources also highlight ways the system itself seems to be bypassed, like legislative shortcuts.
Ah, yes. Two main tactics get mentioned quite a bit. First, the increasing use of the money bill route.
Okay, explain that simply. Why is that a problem?
Well, a money bill has special status. Crucially, the Rajya Sabha, the upper house, which represents the states, has very limited powers to amend or reject it. So if a bill is controversially labeled a money bill, when maybe it isn't purely financial...
It effectively bypasses the scrutiny of the Rajya Sabha.
I see.
I see. And the other tactic?
The ordinance route. This allows the government to bring in laws almost immediately by decree when Parliament isn't in session. They are supposed to be for emergencies.
But the concern is they're being used too often, essentially skipping parliamentary debate and scrutiny altogether.
That's the argument presented in the sources, yes. That overuse of ordinances undermines the legislative process laid out in the Constitution.
Okay, so we have reduced committee scrutiny, lost parliamentary time, and these procedural shortcuts like money bills and ordinances. It paints a picture of, well, a process under strain.
Definitely under strain. And that's where this idea of involving the Interstate Council comes in.
Right, so connect the dots for us. How does bringing the ISC into the picture before a bill hits Parliament potentially fix these issues?
The thinking is this. The ISC is inherently a federal body. It brings together the center and the state governments. It's a multilateral forum.
Okay.
So if you table a bill of national importance there first, you're essentially building in a layer of federal consultation right at the beginning, before the battle lines in Parliament are drawn.
So it forces a discussion between the center and states early on.
Precisely. It could help address concerns from the states up front, potentially reducing conflict later. It aims to rebuild that trust deficit we talked about.
And align the law better with the Constitution's federal principles.
That's the idea. Making sure the states feel their perspectives are considered on laws that will impact them significantly. It's proposed as a way to reform the process, make it more collaborative, more transparent, perhaps.
Interesting proposal. But I can already hear the counterargument. Wouldn't this just add another layer of bureaucracy? Couldn't it slow things down massively, maybe even give states a sort of veto over national laws?
That's a fair point and a potential risk, certainly. The sources don't suggest the ISC would have a formal veto power, more consultative role. But yes, adding steps can add time.
So it's a trade-off.
It seems to be framed that way, a trade-off between speed and federal legitimacy, perhaps. The argument is that getting that early buy-in and consultation, even if it takes longer, might lead to better, more accepted laws in the long run, especially in a country as diverse as India. It's about strengthening the foundation of the lawmaking process itself.
Okay, that makes sense. A complex problem with a potentially complex solution. Let's shift gears now. We're moving from the heights of national parliament right down to the grassroots. This brings us to a core principle mentioned in the material, subsidiarity. The question is, what do you understand by the principle of subsidiarity? Discuss its importance in the context of India.
Right, subsidiarity. It sounds technical, but the core idea is actually quite simple and really important for governance.
Break it down for us.
Okay, so in essence, subsidiarity means that tasks or functions should be handled by the lowest level of authority capable of handling them effectively.
Meaning a central government shouldn't be doing things that a state government, or even better, a local village council, could do just as well, or maybe even better.
Exactly. If a decision primarily affects a local community, say, fixing a local road, managing a neighborhood park, running a primary health clinic, that decision and the power to act on it should ideally rest with that local community's governing body.
Why is that considered so important? What's the goal?
The goal is really about deepening democracy. It's called democratic decentralization. When decisions are made closer to the people they affect, you get more participation, people feel more ownership, maybe more self-reliance.
And potentially more efficient administration, too,
Right.
because local people know local needs best.
That's the theory, yes. Efficient administration and genuine grassroots democracy. It empowers people at the local level.
And how does this connect to India specifically?
Well, the sources note that this idea isn't entirely new to India. You can find echoes of it in ancient concepts like sabhas and samhitas. But in the modern constitutional framework, it really took concrete shape with the 73rd and 74th Amendment Acts back in 1992.
Ah, the Panchayat Raj and municipality amendments, the ones that gave constitutional status to local self-government.
Precisely. Those amendments were meant to be the vehicle for implementing subsidiarity, for empowering local bodies across rural and urban India.
Okay, so the principle is sound. The constitutional amendments have been in place for, what, 3 decades now? Which leads directly to the next question from the sources. Even after 3 decades of constitutional amendments, India is yet to decentralize power to local self-government institutions in the true sense. Discuss. Why hasn't it fully happened if the idea is so good and it's in the Constitution? Where's the disconnect?
Well, that's the million rupee question, isn't it? There seems to be a huge gap between the constitutional vision and the reality on the ground. The sources are quite blunt about this.
What's the main obstacle identified?
It consistently comes down to something the material calls the problem of the 3 Fs.
The 3 Fs.
Yeah.
This seems critical. Let's spell it out clearly for everyone listening. What are they?
Okay, the 3 Fs that plague these local self-government institutions, the panchayats and municipalities are. First, funds.
Money, or the lack of it.
Exactly. Local bodies are often desperately short of financial resources. They tend to be heavily dependent on grants and transfers from the state governments, which can be unpredictable, insufficient, and, well, come with strings attached. It makes independent planning almost impossible.
Okay, so funds is the first F. What's the second?
The second F is functions. There's often a real lack of clarity about what these local bodies are actually supposed to do, which responsibilities are truly theirs.
You mean ambiguity, overlap with state departments.
Yes, lots of ambiguity. The roles and responsibilities aren't always clearly demarcated between the state level and the local level. This can lead to confusion, turf battles, and ultimately inaction. Things fall through the cracks because nobody is quite sure whose job it is.
Okay, funds, functions, and the third F.
The third F is functionary. So this refers to the actual staff and the real authority given to local elected representatives and officials.
So they might have the position, the title, but not the actual power or the personnel to get things done.
That's often the case. They lack adequate administrative support, technical staff, and sometimes the genuine authority to make and implement decisions effectively. They might be accountable on paper, but lack the tools to deliver.
And the sources suggest the root cause for these 3F problems is reluctance from the states.
That seems to be a major factor highlighted. State governments and sometimes state bureaucracies can be hesitant to genuinely devolve these funds, functions, and functionaries. They prefer to keep control, both financial and administrative.
And things like district planning committees, which were supposed to integrate planning from the bottom up, those haven't really taken off everywhere either.
Many of the provisions in the amendments that were perhaps more voluntary or enabling in nature haven't been fully implemented across all states. The political and administrative will hasn't always been there.
It sounds quite challenging. Are there any positive steps being taken? Any way forward suggested?
Well, the sources do mention some initiatives. For example, the Rashtriya Gram Swaraj Abhiyan, RGSA.
RGSA, okay. What's that about?
It's described as a centrally sponsored scheme focused on capacity building. So training local representatives, improving their skills, making them more aware of their roles and powers. It also aims to help empower vulnerable sections within those local bodies.
Like skills training, helping them understand budgets and schemes.
Exactly, things like that. The motto mentioned is Sabka Sath, Sabka Gaun, Sabka Vikas, aiming for inclusive development starting from the village level. Capacity building is definitely helpful.
But capacity building alone won't fix the 3 Fs, will it? If the structure itself doesn't give them money or clear roles.
Correct. It helps, but it doesn't solve the fundamental structural problem. For true decentralization, the sources point towards more fundamental reforms.
Like what? What's the big idea for structural change?
One key recommendation that comes up, I believe, from the Second Administrative Reforms Commission, ARC, is the idea of activity mapping.
Activity mapping, what does that mean?
It means systematically and clearly defining which level of government is responsible for which specific activities within various sectors, health, education, sanitation, etc., drawing clear lines.
So no more ambiguity about functions.
Exactly. An even stronger suggestion mentioned is actually creating a dedicated local body list in the 7th schedule of the Constitution.
Ah, like the union list and state list. A separate list just for local governments.
Precisely. That would constitutionally guarantee their functional domain and, ideally, link it to guaranteed financial resources. It would make devolution less dependent on the whims of state governments and give it real teeth.
That sounds like a much more fundamental shift, giving local bodies their own guaranteed space in the constitutional structure.
It would be a major step towards realizing that principle of subsidiarity we started with, making grassroots democracy truly functional.
A powerful idea indeed. Okay, let's move to our third and final major theme for today. This one. Well, it hits close to home for many. We're talking about the justice system. The source material doesn't mince words here. It starts with a pretty stark assessment. The question is framed around this. A dysfunctional criminal justice system, absence of well-considered legislation, and need for domain expertise are being seen as the new challenges for the Indian judiciary. Discuss. Let's focus on the dysfunctional aspect first. What evidence points to that?
The evidence cited is, well, it's quite sobering. One figure that really stands out is about undertrials.
People in prison awaiting trial, not yet convicted.
Yes. The sources state that approximately 65%, nearly two-thirds of all inmates in Indian prisons fall into this category.
65%. Just pause and think about that. 2 out of every 3 people behind bars haven't actually been found guilty of a crime by a court.
It's a staggering statistic. And it points to a fundamental issue with the system's ability to process cases in a timely manner, severely impacting personal liberty. It's a failure of the justice delivery mechanism itself.
And this ties into the infamous backlog, doesn't it?
Absolutely. The sources mention a backlog of over 30 million. That's 3 crore pending criminal cases alone. We're not even talking about civil cases here.
30 million. It's almost impossible to comprehend that scale. And the delays.
The delays are epitomized by that common date after date after date, endless adjournments, cases dragging on for years, sometimes decades. This dysfunction is linked not just to inefficiency, but also, as the question notes, sometimes to poorly drafted laws or lack of specialized knowledge in certain areas.
Okay, so the system is clearly overwhelmed, leading to massive injustice for undertrials and endless delays for everyone else. This is where technology comes in as a potential savior, right? We see things like the Gujarat High Court live streaming its proceedings, which is fascinating. This leads to the next question. Technology has the potential to bring drastic changes in the field of law and transform the court system. In this context, discuss the need for digitization of the Indian judiciary and challenges faced in this regard. What's the core need driving this push for digitization, for e-courts and digital records?
Given the scale of the crisis we just discussed, the need is immense. Technology offers potential solutions on multiple fronts.
Like what? What are the big benefits?
Well, first, there's the basic issue of space. Courts are drowning in paper records. Digitization can massively reduce the need for physical storage. Think of all those rooms filled floor to ceiling with files.
Okay, space saving. That's practical. What else?
Accessibility. Imagine being able to instantly track a case file, access judgments, or transfer records electronically between a trial court and an appellate court. No more lost files or delays in physically moving paper across cities or states.
That would certainly speed things up. And transparency. You mentioned live streaming.
Yes, transparency is a huge potential benefit. Live streaming proceedings, making case statuses available online, it opens up the judicial process to public scrutiny, which can build trust and accountability.
So better space management, faster access to records, more transparency. What's the ultimate goal?
Efficiency. All of this should, in theory, contribute to speeding up the delivery of justice, making the process smoother, faster, and more accessible for everyone involved, litigants, lawyers, judges, and the public.
It sounds almost like a magic bullet for a system creaking under its own weight. But as always, it can't be that simple. If it were, we'd have done it already. What are the roadblocks? What challenges does the source material identify in actually digitizing the entire Indian judiciary?
The challenges are significant, and the sources seem to group them into, broadly, 3 main areas.
Okay, let's break them down. Challenge number 1.
Basic infrastructure. This is a huge one. You need reliable computers, stable electricity, and crucially, high-speed internet connectivity. This infrastructure is often lacking, especially in lower courts, district courts, and particularly in rural areas. You can't have an e-court if the power goes out or the internet is down half the time.
A fundamental practical barrier. What's the second big challenge?
Cybersecurity. This is incredibly important and, frankly, quite scary. Judicial data is highly sensitive. Case files, witness statements, judgments, personal information. If these digital systems are vulnerable to hacking or data breaches,
The consequences could be disastrous.
absolutely. The sources mention a recent incident at AIMS, the hospital, where sensitive patient data was compromised. Imagine something similar happening with court records. It could undermine the entire system's integrity. Protecting this data requires constant vigilance and significant investment in robust security measures.
Okay, infrastructure and cybersecurity. What's the third major hurdle?
It's the human element. The digital divide and digital literacy.
Meaning,
First, that large sections of the general population may lack the skills or even the access to use digital court services effectively. If people can't navigate the online systems, digitization doesn't improve access for them. It might even create new barriers.
but it's not just the public, is it?
No. Crucially, the sources point out that digital literacy can also be a challenge within the system. among judicial officers, court staff, and even lawyers themselves. If the people running the system aren't comfortable or proficient with the technology, its potential benefits won't be realized. You need comprehensive training and ongoing support.
So it's a massive undertaking. It requires not just buying computers, but ensuring reliable infrastructure everywhere, building Fort Knox-level cybersecurity, and undertaking huge digital literacy drives for both the public and the professionals within the system.
Exactly. It needs sustained political will, significant financial investment, especially in R&D for security, and a real commitment to training and adaptation.
And the justification for all this effort goes back to something fundamental, doesn't it? The sources link it to Article 21 of the Constitution.
Yes, the right to life and personal liberty. The argument is that access to timely justice is an implicit part of this fundamental right. Therefore, overcoming these challenges to make the justice system functional, including through technology, isn't just desirable, it's arguably a constitutional necessity, upholding the right to justice.
That really ties everything together. So if we step back and look at the bigger picture from all three segments, lawmaking, local power, justice, what's the common thread?
I think the common thread running through all the source material is the challenge of making India's constitutional framework truly effective and responsive in the 21st century. It's about ensuring the institutions of governance work for the people.
Making the Constitution a living document, as they say, adapting it to modern realities.
Precisely. Whether it's ensuring laws are properly debated and reflect federal consensus, or empowering local communities to manage their own affairs, or making sure the justice system actually delivers justice without crippling delays. It's all about strengthening the institutions and building or rebuilding trust. Trust between levels of government and trust between the citizen and the state.
That's a great synthesis. Okay, before we wrap up, let's do that active recall session. We've covered a lot of ground. Let's try and lock in the key takeaways from each section. Ready? Ready when you are. All right, first section, national lawmaking. The proposal was to involve the Interstate Council before bills go to Parliament. What are the main problems this was trying to address? Give me the key concepts.
Okay, the core issues were the decline in parliamentary scrutiny, particularly bills not going to committees, and the frequent use of procedural shortcuts like the money bill route and the ordinance route, which bypassed checks and balances. The overall aim was to reduce the center-state trust deficit by ensuring federal consultation.
Perfect. Scrutiny, bypassing checks, and the trust deficit.
Got it.
Now, second section, local power and the principle of subsidiarity. What are those infamous 3 Fs that are holding back panchayats and municipalities?
The dreaded 3 Fs. They are lack of funds, financial dependence, lack of clearly defined functions, ambiguity in roles, and lack of adequate functionaries, staff, and real authority.
Funds, functions, functionaries. Nailed it. Okay, final section, the justice system and digitization. We know about the huge backlog and the under-trial crisis, but what were the 3 main challenges identified in actually implementing digitization across the courts?
The 3 big hurdles were inadequate digital infrastructure, connectivity power, major cybersecurity risks, protecting sensitive data, and the digital divide, which includes the lack of digital literacy among both the public and the judicial system's own personnel.
Infrastructure, cybersecurity, and the digital divide literacy.
Excellent. That really helps solidify the core problems and proposed fixes. Thank you so much for bringing all this source material together for us. It's been a really insightful deep dive into some critical areas of Indian governance reform.
It certainly covers some fundamental challenges.
And I think the big takeaway for you, the listener, is that fixing governance isn't about finding one single magic solution. It's a continuous effort, isn't it? It requires improving transparency way up at the national level.
While also genuinely empowering communities right down at the grassroots level.
And crucially, leveraging tools like technology effectively and thoughtfully to make core systems like justice delivery actually work for the citizen.
It's about that constant process of adaptation and strengthening institutions.
Exactly. Now, to leave you with something to chew on, a final provocative thought, building on the material. We heard the sources mention the Basic Structure Doctrine, the idea that the judiciary protects the fundamental essence of the Constitution.
Yes, a crucial concept. So, consider this. If a criminal justice system where almost 2/3 of prisoners are under trials, potentially denying them their fundamental right to justice under Article 21, their right to liberty, if that's seen as undermining the basic structure of the Constitution, then setting aside technology for a moment, what structural change, what non-tech reform within the justice system itself do you think is the single most urgent priority to protect that basic structure, to safeguard liberty for every single citizen?
That's a tough one. Moving beyond tech fixes to the core structure, a really profound question to ponder.
Something to think about. Thanks again for joining us for this deep dive.
Thank you.
We'll catch you next time.